Hey, today we're going to tackle the question, how do I know if my invention is patentable? I am JD Houvener, owner and founder here at Bold Patents Law Firm. I'm a patent attorney that's been working with inventors for over 10 years. I've helped inventors earn over 400 patents as of today, and I'm excited to talk with you about this question. So, how do I know if my invention is patentable? This is huge. Great ask, good question, right? Because it means a lot. And let's unpack it. There's about 3 different things to look at to see if it's patentable. The first one is eligibility. First and foremost, does your invention fit into the realm of patent law? And most inventions do. There's a few exceptions. And there's abstract ideas, laws of nature, or things that have already been patented before. Okay, so let's go over the first one, which is abstract ideas. These are things that are really hard to put into words and definitely really hard, if not impossible, to actually touch and feel, right? Tangibility is really lost. When you're trying to explain the idea, it really is kind of more of a common everyday thing that we do, right? As humans do, right? Some processes that already occur in the brain, or where 2 people are just conversing or talking, and there really isn't any ingenuity. There really isn't any added extra something, right? That technical solution, that brilliance that we're looking for when it comes to inventions. That will get you into the realm of patentability. But if it really is just more about common everyday stuff, or if it's about things that are so abstract and hard to actually grab onto, moreover, would be hard to enforce, the patent office is not going to grant that. So the second one is probably the bigger, more easier to understand one, which is laws of nature. If you've discovered a new equation, right, a new law of physics, you've discovered something about, in the water or in the environment, in the world, and you found a new mineral. Well, that discovery itself is really part of nature, and it isn't something that you as a human created or made with your own mind and intellect. And so you can't own that. It's a part of the world, it's a part of nature, and a law of natural phenomena. And of course, you cannot patent something that's already been patented. And so if you know that, it's already been done and it can't be patented again. It's now part of what's called the public domain. All right. Everything else is, in general, eligible. So that's hurdle number 1, is eligibility. Number 2 is this concept of, is it patentable? And there's 2 concepts there. Is in order to get a patent, you must be the first of its kind in the whole world. That's novelty. And then it can't be an obvious version of something else that's come before it. So that's non-obviousness. And then for utility patents, it has to have some present benefit, some utility that'll help people, help the world in some way. So those are the 3 hurdles to clear once you've gotten over eligibility. So novelty, to do research to see if your invention is really the first of its kind, will take some effort, right? Some diligence. And you should start by doing your own research, making sure you've looked over what you've looked at in your industry, or if you're new to this industry, inventing outside of what you do normally every day, take some time, do some research online, look at some books, talk to a few people that work in the industry, and see, hey, is this really something unique? Have they ever seen this before? Now, when you're talking with third parties, do be careful. If you're going to be discussing in full detail what you've discovered, what you've invented, make sure you have a non-disclosure agreement in place. Now, if you can do the research on your own, you convince yourself that it's unique, now it's time to hire a patent attorney and get a legal opinion on whether this really is the first of its kind. Attorneys like ours here at Bold have resources and use third-party research tools to confirm patentability and go look at all patents, all applications, and any published patent, non-patent literature that's been sent out before to see if it's been really the first of its kind. The second hurdle is non-obviousness, and that takes a little bit of a careful eye. And so it might be worth your time talking with a professional to see if they can help you understand whether, well, even though it's brand new, this other, previous publication or previous patent, it's so close. And if we put it together with this other one, people in the industry would probably know and it would be obvious. And so that might be one of those things that just you decide not to file or not to move forward with the patent application because your invention really is an obvious version, an obvious variation of what's come before. So those are the big things to think about when it comes to patentability. I know I talked about a lot there, and if you have any more questions, please get a hold of us and download the free Inventors Kit below. That's going to have a lot more information about your decision on how to go about a patent search, your options that you have, and different cost structures, different quality levels, all the way from doing it yourself to hiring a patent attorney like I talked about today. So hopefully help answer your question about patentability. I'm JD Houvener, patent attorney, owner here at Bold Patents Law Firm. Have a great day, everybody. Go big, go bold.